said, no, you cannot be that broad. So it's very important to look at who the beneficiaries are of the trust and not deviate from that, because none of the 22 states that allow by statute, trust decanting will allow you to name new beneficiaries. What happens if you're not in a decanting-friendly state? Got to look at the trust document. I like looking at the trust document even before I'll look at statutory decanting to see if the trust allows to change trust situs. If it does, we're in a better position, in my opinion. Here in New Jersey, we're left with, again, common law decanting. What that means is if you look, I cite to the Wiedemeyer case. That was an appellate division case in 1969 that said you had a trustee that had the ability to make discretionary distributions to multiple beneficiaries. So in essence, the trustee could distribute to anyone they wanted to in a class of beneficiaries. The court in Wiedemeyer, which almost every state cites to for this premise, said, in essence, you could move those assets to a new trust for the benefit of those beneficiaries. It's the same thing. The problem is, if we're going to rely on common law decanting, there takes a risk, and I've done it with clients, but you have to be very careful, because if you do it, and either you get a court order or you don't, there's an issue as to whether a beneficiary down the line could challenge that quote-unquote common law decanting. I want to talk about a case in Massachusetts that's very appropriate. It's Morse v. Kraft. It is the Kraft family that owns the Patriots. There was a trust that was created, and this is before Massachusetts had a decanting statute. This sort of created the decanting statute in Massachusetts. You had a trust that had multiple beneficiaries, 4 beneficiaries. The trust document itself stated that all 4 beneficiaries could not be the trustee. The existing trustee now is getting into retirement age, and the beneficiaries themselves wanted to be the trustee. So the court here went and asked the IRS for a ruling on this, went into Massachusetts court, and tried to get a ruling allowing the decanting. They were successful. After the fact, Massachusetts passed this Uniform Trust Code, which New Jersey has not done. And the court in its dicta said, in the future, if you come back to the court and ask for the ability to decant, it better be in the document, otherwise they most likely won't grant it. Don't know where that's going because there hasn't been another case, but it's sort of a scary proposition. And other courts, if I was writing a brief, I would cite to that for that premise if I was someone that didn't want the decanting to happen. Very near and dear, and a very important case in the special needs world is in the matter of Kroll, which is a New York case which was decided in 2013. In that situation, we had a trust that was created for, at the time, was a 19-month-old child. So parents created a trust for child. Child at the time did not have special needs, developed special needs. At age 21, the child was supposed to get a distribution of income. The child also had the ability to request principal, full distributions of principal. 6 days before the child turned 21, someone woke up, and under New York law, we have a statutory decanting statute. So they provided notice. In New York, you need to provide notice to the beneficiaries. They provided the relevant notice and then went to court. And they served the Attorney General of the state of New York, who had an interest in this, because at age 21, that child currently is receiving government benefits from the state of New York, SSI, SSD, and other government New York benefits. At 21, if that child has the right to a couple of $1 million in a trust, it would disqualify them from government benefits. New York, through the Attorney General and the Department of Social Services, vehemently challenged this and said, look, this is not allowable. It's, in essence, the same thing as creating a self-settled trust, where I, as the special needs beneficiary, create the trust, and if it's a self-settled trust under New York law, you have a Medicaid payback to the state of New York when the beneficiary passes away. The purpose of the decanting was to move the trust assets into a new trust that had a special needs trust built into it. The court allowed it in this case. I think the defining issue here, and what's very important, and it's not being talked about enough, is I don't know if we have the same result if that beneficiary who had special needs was 21 or older when this happened. So it's very important, and after this I wrote a letter to all of my clients telling them that had special needs individuals or anyone that recently created a trust, saying if that's an issue, I want to take a look at this before there's vesting inside the trust if there is vesting. What we didn't talk about today, we have trust decanting, we have potential trust construction actions. Are we going to do a statutory decanting, or are we going to do a common law decanting, or are we going to do a typical trust decanting if the trust has the ability to do that with language in the document? What's the fiduciary liability of the trustee on this? So typically it's the trustee that has the ability to distribute assets. It's the trustee's decision as to do we go to court, do we do a decanting. Is there unintended consequences if the trustee does something and then it's challenged, which is my concern with a common law decanting. I typically will avoid it because I want to rely either on a statute or the trust document itself, because if I rely on state law and the Wiedemeyer case doesn't protect me because the facts aren't the exact same facts, I think there's liability for the trustee. Also, IRS has made a ruling, and I call at least once or twice a year now. In 2011, ruling 2011-101 came out. An attorney with the last name of Kim wrote the ruling, and they will not rule on whether there's GST, gift, estate, or income tax consequences to a decanting. They won't issue a PLR. They will do none of it. So it's an unknown position as to whether there is. I shouldn't say it's an unknown position. It is. There are consequences potentially if you decant from an IRS and a federal tax perspective. To me, depending on the facts, those are minimized. There are Treasury regulations for GST purposes, meaning if there's a dynasty trust and we decant into another dynasty trust, I want to make sure I'm within Regulation 2601-101 to deal with that issue. But really no formal guidelines issued by the IRS dealing with this. So there is some risk, but really the facts should tell you. If there's debt inside the trust, I would tell you that you have a major consequence potentially there. If there's not debt inside the trust, most of the time I'm going to feel comfortable doing something with this, because what's the other option? If you have a trust that age 35 distributes assets to someone getting divorced or that has a special needs situation, you're better off at that point taking that risk. So if there's anything I want you to take from today, it's really if there are irrevocable trusts, and I know all of you have clients that have irrevocable trusts, make them take a look at them. It's important to pull them out every 3 to 5 years to look at what can you do if there's something that has changed, there's changed circumstances, and we need to make modifications. It used to be, that was the deal. You had an irrevocable trust. New York in 1992 sort of changed that game with the first decanting statute, and then you had 21 other states thereafter followed suit. It's a vitally important position. It's vitally important to look at this. Over the last 5 years or so, there have been more, in my practice, more decantings and more construction actions than I've ever had. And I think it's because it's starting to become mainstream in the trust decanting world, and I think people are taking it seriously. And I think the courts also understand that things change. Most of the time when people create irrevocable documents, inevitably 30 years later, 20 years later, 10 years later, there's a change in someone's life. I hope that was beneficial to everyone, and I encourage you to really advise your clients to take a look at your irrevocable trust situation. Thank you.
Stephen Loeb, thank you. Steve, thank you so much.